Virtual Lesson 3.4 Delivering Criminal Justice. Due to the serious nature of the rights and freedoms at stake, the determination of guilt or innocence in criminal matters needs to be systematic, predictable, and beyond the influence of opinion or sentiment. The sentencing that follows a conviction, however, involves the consideration of many different factors and may be the part of the criminal process that requires judges to use the most judgment. Plea bargaining. In Canada, over 80% of all criminal charges are disposed of through plea bargaining. It is the process in which the accused negotiates with the Crown and agrees to plead guilty in exchange for a lesser charge, or fewer charges, or a recommendation for a lighter sentence. The parties can then proceed directly to a sentencing hearing without the need for a trial. This, in general, makes the system more efficient for all involved. Although the accused gives up their presumption of innocence, they gain some certainty related to sentencing. They also avoid the additional time, stress, public exposure, and possibly expenses related to a full-blown trial. The Crown saves time and money and avoids the requirement of proving their case beyond a reasonable doubt. An additional benefit to the criminal justice system is that court resources are freed up for the more serious or contentious cases. The Rules of Professional Conduct, published by the Canadian Bar Association, encourages defense lawyers to advise their clients as to the strength of the case against them and the implications of a guilty plea. Once a client admits to the necessary elements of the charges against them and consents to entering into an agreement with the Crown, the lawyer may then bargain on their behalf. This process puts a lot of power into the hands of Crown prosecutors. It may be argued that they are acting as judges and juries insofar as they are deciding both the guilt and the sentences of the accused through their bargains and their recommendations to the court. In some cases, this usurping of power raises concerns. One recent example occurred in the case of Karla Homolka, when in 1993 her lawyer plea bargained to a lesser charge of manslaughter after her direct involvement in the well-publicized murders of two schoolgirls. The public responded with outrage due to the relatively short sentence that she received. Despite the potential for such injustices, Ontario Crown attorneys are required to recommend a sentence at the bottom end of the normal range when there is an early guilty plea. Sentencing. Sentencing hearings are always held after criminal conviction, regardless of whether it resulted from a plea bargain or a trial. The philosophy of sentencing in Canada traditionally included four goals: denunciation, specific and general deterrence of the accused and of the public respectively, separation from and the protection of the public, and rehabilitation. As mentioned above, sentencing involves a great deal of judicial discretion. Although the Criminal Code sets the maximum term of imprisonment for each offense, for the most part, the type and quantum of each sentence is determined by the presiding judge. In some more serious or controversial offenses, the judge's discretion is limited due to statutorily prescribed minimum penalties. For example, the minimum penalty for first-degree murder is life imprisonment without eligibility for parole for 25 years. Other examples include offenses involving the use of a firearm and impaired driving. Statutorily prescribed minimum penalties can raise public concern when legal or moral guilt is controversial. The 2001 Supreme Court of Canada case R.V. Latimer involved the mercy killing of a 12-year-old girl who suffered from a severe form of cerebral palsy. Her father was found guilty of second-degree murder and sentenced to life imprisonment without eligibility for parole for 10 years. In upholding the conviction, the Supreme Court rejected the argument that the sentence amounted to cruel and unusual punishment, thus violating Mr. Latimer's Section 12 charter right. The court stated that although the facts did not trigger considerations of the specific deterrence of Mr. Latimer, separation from and the protection of the public, or rehabilitation, the goals of denunciation and general deterrence were critical in this case to discourage like-minded people from committing the same offense in the future. The sentencing hearing. Sentencing may take place immediately after conviction or after an adjournment, during which the Crown and the defense lawyer may gather evidence and develop their arguments. Sentencing hearings are less formal than trials. The rules of evidence are relaxed, and the process becomes more conversational among the judge and the lawyers. In addition to the submissions by the Crown and the defense, documents may be filed with the court to assist the judge. The pre-sentence report is typically prepared by a probation officer. It contains information about the person who has been convicted and their offenses, and it may also contain a recommendation for sentencing. Victim impact statements may also be filed to provide information about the indirect consequences of the offenses. Sentencing reform, amendments to the Criminal Code. In 1987, the Canadian Sentencing Commission called for reform, eventually leading to the enacting of Bill C-41 in 1996. One aspect of this legislation was the expansion and codification of the goals of sentencing. Section 718 of the Criminal Code now lists the following 6 objectives. A. To denounce unlawful conduct. B. To deter the offender and other persons from committing offenses. C. To separate offenders from society where necessary. D. To assist in rehabilitating offenders. E. To provide reparations for harm done to victims or to the community. And F. To promote a sense of responsibility in offenders and acknowledgement of the harm done. The last 2 objectives were new and heralded the recognition of victims in the criminal justice system. These changes to the philosophy of sentencing arose after a government task force had determined that too often people are victimized twice, once by the offense and once more by the process, and after the lobbying efforts of a number of victims' rights groups. This philosophical shift has been referred to as a move toward restorative justice, which views offenses as more than just conflicts between an offender and the state. They also involve the victims and the community, and therefore all of these interests should be considered and involved in the resolution. To help achieve the balancing of these interests, Section 718.2 contains a number of aggravating and mitigating circumstances that the court must consider when imposing a sentence. In the 1999 decision in R. v. Gladue, the Supreme Court of Canada confirmed the restorative interpretation of Section 718 and noted that the new provisions of the Criminal Code require judges to always consider and prefer alternatives to imprisonment if they are appropriate in the circumstances. Gladue was an Aboriginal, and one important result of this decision is that a court may now request a Gladue report, which is a pre-sentencing report with particular details about the heritage and experiences of an Aboriginal person convicted of a crime. The principles of restorative justice are very similar and can be at least partly attributed to the traditional Aboriginal approach to criminal matters. Sentencing reform, restorative justice programs. There are many restorative justice programs currently operating in Canada which bring victims and wrongdoers together along with trained facilitators. Victims are given the opportunity to address and question the offenders, who are in turn given the opportunity to speak. Strategies and schedules for reparations are decided upon and later monitored. The goals of these programs are the restorative ideals of the recovery of the victim and the reintegration of the wrongdoer. Sentencing reform, circle sentencing in Aboriginal communities. The Canadian legal system has a long history of failing to address the interests of Aboriginal peoples. At disproportionately high rates, they have been arrested, denied bail, unrepresented in court, and imprisoned. In 1992, Judge Barry Stewart, sitting on the Yukon Territorial Court, included in his reasons for R. v. Moses his belief in the value of traditional models of justice found in Aboriginal communities. In the sentencing for that case, the court used a process called circle sentencing. About 30 people, including the offender, the Crown, and defense lawyers, the judge, members of the offender's First Nation, police and probation officers, were seated in a circle facing each other. All members then introduced themselves and proceeded to have informal discussions about both protecting the community and helping the offender find a better path in life. Moses' sentence was 2 years of probation with conditions involving spending time with and working with his family, supervision by Aboriginal elders, and treatment for his alcoholism. These restorative measures had all been personalized to meet his needs. Sentencing options. Section 718.1 of the Criminal Code requires that a sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Aside from some offenses that carry mandatory minimum or maximum penalties, judges have full discretion to choose from among absolute discharges, conditional discharges, probation, fines, intermittent sentences, conditional sentences, and imprisonment. Absolute discharge. If a judge wishes to avoid imposing the stigma and negative consequences of a criminal record, they can grant an absolute discharge. A person found guilty can request an absolute discharge for any offenses that do not carry a mandatory minimum penalty or a maximum penalty of 14 years or life. The judge may grant the request if it is deemed not to be contrary to the public interest. Conditional discharge. In comparison with an absolute discharge, a conditional discharge requires the offender to follow conditions such as reporting to a probation officer, attending a program, abstaining from alcohol, or avoiding certain people. Benefits of discharges. Discharges are often granted to help the offender avoid future problems with immigration or employment. An offender who receives a discharge is deemed not to have been convicted. They can answer no when asked whether they have a criminal record or a previous conviction. If, however, an interviewer is permitted to ask whether they have ever been found guilty of an offense, the response should be yes. Probation. Probation orders allow offenders a greater measure of freedom, such as avoidance of imprisonment or a shorter stay in prison, in exchange for their compliance with certain conditions. All probation orders include the mandatory conditions of good behavior, appearing before the court when required, and keeping the court or the probation officer informed of any changes in circumstances. Probation orders may also include optional conditions, such as reporting regularly to a probation officer, abstaining from alcohol or drugs, performing community service, providing care for dependents, or making restitution. Fines. Fines are often imposed for less serious offenses. Offenders found guilty of summary conviction offenses may be subject to a fine up to $2,000. There is no upper limit on fines for indictable offenses. After a 1996 amendment to the Criminal Code, judges must now consider the offender's ability to pay a fine. The amendments also created more flexibility to ensure the payment of fines, such as extended payment schedules, the option to work off fines instead of paying them, and the garnishing of wages, where money is automatically deducted from the offender's paycheck. Section 737 of the Criminal Code requires the courts to impose a victim fine surcharge following any conviction or discharge unless it would cause undue hardship to the offender. The surcharge may be up to 15% of a fine or up to $10,000 if no fine had been imposed, with the proceeds going toward funding provincial victims' services. Intermittent sentences. Judges may order that prison sentences of 90 days or less be served intermittently. For example, a 30-day sentence could be served on the weekends for a period of 15 weeks to allow the offender to attend school, work, or care for dependents. Conditional sentences. Conditional sentences are another product of the 1996 Criminal Code amendments that were aimed at reform. They allow for prison terms of less than 2 years to be served in the community. Incarceration is now used only as a last resort for the most serious crimes and the most dangerous offenders. A conditional sentence will include conditions similar to probation. As long as the conditions are met, the offender is able to serve his or her sentence in their home, or another agreed-upon location, sometimes subject to electronic monitoring. House arrest is in line with the principles of restorative justice, de-emphasizing the goals of denouncing, deterring, and separating, while increasing the chances of achieving rehabilitation, responsibility, and reparations. Imprisonment. Offenders who receive prison sentences of less than 2 years serve them in provincial jails, and those with sentences of 2 years or more serve them in federal penitentiaries. Most people would agree that dangerous offenders need to be imprisoned for the protection of society. However, some would argue that there are far too many people incarcerated, as many of them have been convicted of non-violent crimes, and that the rehabilitative potential of prison is highly suspect. Rehabilitation is generally measured by rates of recidivism, meaning the number of former inmates who return to crime after their release. Alternative forms of incarceration are always being considered to address concerns such as recidivism and the excessive costs of traditional prison. Project Turnaround was one such program in Ontario, where a camp-like facility for young offenders was operated like a military boot camp to instill discipline, responsibility, and accountability. Although Project Turnaround seemed to be improving the recidivism rates of its participants, it was closed by the provincial government in 2003 for financial reasons. Wrongful convictions. The criminal justice system is designed with respect for the rights of accused persons. Investigative and court procedures are in place to promote fairness and ensure that innocent people are not convicted. Despite these safeguards, however, it is understood that wrongful convictions do occur. The well-known cases of Donald Marshall, Guy Paul Moran, and David Milgaard are all examples of individuals who were found guilty of murder only to be exonerated after spending years in prison. Miscarriages of justice such as these did not generally occur due to wrongdoing on the part of the prosecution. They were typically the result of the Crown vigorously pursuing the conviction of an accused person that they assumed guilty. Avoiding these wrongful convictions in the future will require a culture of open-mindedness and honesty among the police and prosecutors. Under Section 696.1 of the Criminal Code, individuals convicted of indictable offenses have the right to apply to the Federal Minister of Justice for ministerial review on the grounds of miscarriage of justice.